All right, ladies and gentlemen, we're going to start the meeting. You know, back when I was a judge, I would, well, you would think that I would pound a gavel, but I never carried the gavel to the bench one time. So I did use a stapler once to do the same thing. All right, pretty much going to go down the list. We'll start out with House Bill 334. We're not taking any more testimony on it. We've done a couple of days of that. I'm going to let the author talk a bit more about his bill, and then I'll open it up for discussion of the committee, and then we'll most likely take a vote. Representative Gullett.
Thank you, Mr. Chairman.
Thanks.
Thanks, members of the committee. I know we've, this is the third time talking about this bill this year, and we discussed it a couple times last year. This is House Bill 334. We have a substitute in front of you today, LC 413007S, and it's a substitute from the substitute that we had the last time we presented this bill. And what that, I'm going to just go over quickly what the changes were that we made to that substitute, because I think it was talked about pretty in depth. What we did was we added on line 108, we added a definition for real estate document. That was at the request of the Georgia State Bar. So that's added there. And then we struck out on line 438. It said, it was section C of the original of the last substitute, said except as provided under subsection D of this code section. And then it goes on to say a remote online notarial act performed by a remote online notary public commissioned or registered in another state has the same effect under the laws of this state as if performed by a notary public appointed in this state. So what we did is we struck out the except as provided under subsection D of this code section. And then we removed code section D. And so that was talking about the remote online notary public who is not commissioned by a state of Georgia shall not use remote online notarization to attest or acknowledge a document pertaining to real estate in the state. And that was really at the request of the bar. They believed in title folks. They believed that there would be titling issues if we kept that in there. And then also the other change we made was last time's bill was at line 448. There was a section 4517 8.12. And that was at the request of the community bankers, and they've agreed to allow us to strike that language. There's an AB 1, 2, and an AB. We've struck that language out, so it's no longer in the sub now too. And that's referring to notarial act performed by remote notary public shall be presumed valid, regardless of any failure of remote online notary public to perform a duty. And that was struck out because the title folks said that would, they were completely against it. They want title loans in the state of Georgia. So, or title property in the state of Georgia. So, and then I just wanted to call your attention. I have a letter on the desk as well. And it's related to the interested parties in their current positions, because I know there's been a lot of talk about that. I think that you'll see there's a overwhelmingly number of supportive people of the legislation. American Council of Life Insurers, we got insurance folks, we got title folks, bankers, Georgia Chamber of Commerce, Georgia's own credit union, League of Southeastern Credit Unions and Affiliates, Metro Atlanta Chamber, Mortgage Bankers Association of Georgia, State Bar of Georgia, Superior Court Clerks Association, Office of Governor Brian Kemp, and just recently told Fidelity National Title is also supportive of the measure. Not having a position, it says undecided, but probably more fair to say not have a position at this time, would be Georgia Real Estate Closing Attorneys Association and the Georgia Realtors Association. But I'm happy to answer any questions.
Any questions by the committee? None online? All right. Thank you, Mr. Gullett.
Thank you. Thank you very much, members of the committee.
All right. Is there any further discussion by the committee of this bill? Hearing none, I'll accept the motion. Okay, I do have a question. All right, hang on.
And I apologize for being late. Did the, maybe this is better for the author, but there was something in the last sub about protecting making sure we don't have unauthorized practice of law. Is that in here?
That was kept in the legislation.
Okay, thank you.
All right, any other questions? Okay, hearing none, I'll take a motion. Have a motion. Is there a second?
Second.
Motion and a second. All those in favor, say aye.
Aye.
Any opposed? All right, your bill passes.
Thank you, members.
All right, so I'll call on Representative Washburn for his, I guess we'll start with House Bill 470.
Thank you, Mr. Chairman, ladies and gentlemen of the committee. I'm here to present House Bill 470. And this bill has to do with the Condominium Act, and it simply removes the requirement for floor plans for a residential unit. I want to call on Seth Wiseman of Wiseman Law, who asked me to carry this bill. I think it'd be very productive for Seth to give you a quick 2-minute explanation of why this has been needed because of some title issues.
Okay, and while he's coming up, that we're referring to LC 500157.
Yes, I'm sorry, Mr. Chairman, I omitted that.
No problem. All right, introduce yourself and who do you represent?
I'm Seth Weissman. I'm an attorney at the law firm of Weissman. And actually, I'm speaking for condominium developers. I do a lot of work with condominiums, have for the last 40 years, and have written several law review articles. But we work on a lot of very large mixed-use developments. And with mixed use, the way they're now organized legally, when you have a hotel, an office, apartments, they are each condominium units in what you can think of as a master condominium. And most of them are developments where, frankly, the cost of building them is in the hundreds and hundreds of millions of dollars. So as a result, you have some very persnickety lawyers, bankers, and title folks all wanting to make sure that things are done very precisely. And the challenge that we're having with the Act is that you can't file your condominium documents normally until the buildings are built. But the lenders want collateral. They want you to pledge something. So the workaround has been that up front, we create air rights units, and we then pledge those units to the lender in exchange for a construction loan. Hopefully that all makes sense. And in order to create a condominium, you need to file a declaration, a plat, but also floor plans. That's the third requirement of the statute. And there's no way to file a floor plan, if you think about it logically, for a box of air. It just can't exist. And we've explained to the title folks and to the lenders, can't meet one of these requirements. And because so much money is being loaned, it makes them exceptionally nervous. So we are simply trying to clarify, make one tiny clarification to the Act, where what we say is if your unit does not have physical boundaries, there's no need to file floor plans, because you can't file a floor plan for airspace. So that is all this bill does, but it should help ensure that real estate development of large, what I want to always make sure of is that Georgia is competitive with other states. And if we can't get financing for these kinds of projects, it's not good for our economy. So we want to clarify this to make it easier for our developer clients to get loans. We added some language at the end of the bill that clearly says this does not apply to the sale of an individual residential condominium. So if you're buying one condominium unit to live in, of course you would get a floor plan. As a matter of fact, that's required under 2 different sections of the Georgia Condominium Act. So this really has a very narrow context. The other minor change we made is we basically said if you file a condominium plat, which is a survey for your entire property, and you then do a sub-condominium, you don't have to record a plat twice. You can rely on the plat that's been recorded once. So I don't think there's anything in this bill that's controversial. It's really just a tiny cleanup to make it easier for developers to get loans. And I'm glad to answer any questions that you might have. We sure appreciate your help.
All right, any questions by the committee? What's your number over there? You're on.
Yep, I can hear it now. Hey, my name's Rob Leverett. I just had 1 or 2 questions because I
Sure.
don't deal with this area being out in Elbert County. We don't have condominiums at all. So is a sub-condominium a condominium that itself is like part of a larger condominium where, for example, people in one building would pay certain common expenses common to all of the buildings within that property?
Yeah, if you I don't know if you've ever seen those little Russian dolls where you open up one doll and there's another doll inside.
Right.
It's kind of a condominium within a condominium. Sometimes what we'll do is, again, if you have your hotel as a unit, your office as a unit, an apartment or your residences as one unit, we may then take that one unit and submit that to a sub-condominium and sell off individual residences. And there's probably 100 developments like that here in Atlanta. It's become probably the most common way to develop these mixed-use developments that now exist everywhere.
Okay. And when you were discussing earlier about the financing, this air rights concept, so is that primarily something that it just exists between a developer and his lender?
Yes, typically. And then what happens is when the building gets built, we'll go ahead and file an amended and restated declaration because now you actually have a building that now physically exists in space.
And so in a sense, is the lender taking a security interest in the rights, I guess, in the right to cause the building to be constructed in accordance with plans?
Correct.
Okay.
Yeah. And, it also in theory could apply to land as well as to air rights, but they're looking to get as much collateral and protection as they can. So that if for some reason the development fails, they can step basically into the shoes of the developer.
Okay. And jumping back to the sub-condominium thing about no new survey, I'm assuming what happens is you generally do one survey, one that would include all the sub-condominium components of a larger condominium at one time.
Correct. Well, the survey is a top-down view of just the dirt.
Oh, okay. All right.
So if you've got one map of the dirt, there's really no need to, anything that would be a sub would also be shown on that
Included.
dirt.
Okay. I thought you might also just be showing like footprints of the buildings to give that idea, but I would concede you really wouldn't need that to perfect the security interest. Once you've got a security interest in the land, it doesn't matter what they put on it, that becomes part of your collateral.
Correct.
Okay. Thank you.
Any other questions?
Well, again, greatly appreciate your help. Very minor change, but it will certainly help ensure that we can continue with good development here in our state.
Thank you, sir. All right, any further discussion? Anyone like to make a motion? I have a motion. Is there a second? I have a motion and a second. Any further discussion? Any amendments? Hearing none. All those in favor say aye.
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 Any opposed? All right, thank you, Mr. Washburn.
Thank you, Mr. Chairman and members of the committee.
On to House Bill 480.
House Bill 480, we're working from LC 364642. This bill simply adds registered interior designers to the lien law. And I have some brief comments about that. First of all, we should recognize how someone becomes a registered interior designer. They must have an approved 4-year college degree and 2 years of work experience under another registered interior designer. And they pay application fee, make application and pay the fees also to the Board of Approval of the Registered Interior Designers. On the other hand, simply an interior designer can be anybody that states that they are one, so to speak. So there is a difference between the two. Registered interior designers are qualified to submit drawings, submit a seal with their drawings for building permits, to work on more complex structures like petitions, doorways, stairways, and non-load bearing walls. The point is they do more than just choose paint colors and those kind of things. And I'd like for you to focus on what they do in the commercial arena primarily, because they do much bigger things than just choose some paint colors and those sorts of things. The question of why this bill is needed, it is designed to level the playing field and ensure that registered interior designers have access to the financial protection that other professions like architects and engineers already possess. And so currently 23 states contain lien law that protects them. And really simply stated, it's just a sense of fairness. Of course, if a registered interior designer is owed $70,000, and for instance, one of our colleagues in the House told me a story the other day of one of his constituents who was owed $70,000 that they could not collect or could collect, I guess, but they had to go through the process of suing and getting a judgment and all of those sort of things. So it does seem to me that it is just a sense of fairness to protect these people. And so I'll answer any questions about it, but the bill simply adds them to the lien law.
All right. Any questions for Representative Washburn? Yes, sir. 15.
Washman, does this includes not only registered interior designers who are working on commercial property, but if they're working on residential as well?
That is correct.
Okay.
Yes, it is correct. They would be protected in that way as well.
Thank you.
That was. All right. Any other questions? Oh. All right. Thank you, Representative Washburn. We have one person that has signed up, John Guest.
He was on standby for us if needed, and so if you had any questions that we needed his additional, so he is not, he was here if we needed him.
Okay. All right. Thank you. All right. Any further discussion on this bill by the committee? All right. Do I hear a motion? I have a motion to do pass. Is there a second? Have a second? All right. All those in favor say aye. Aye. Any opposed? All right. Representative Washburn, thank you.
Thank you, Mr. Chairman and members of the committee.
Okay. The next bill up is actually my bill. This is House Bill 553, LC 412946. What this bill does is, and this came from the one of the administrative law judges. I don't know. I guess they have a chief over there, and he asked for this to be put into a bill form to allow for remote electronic communication. In other words, virtual hearings in the administrative law process. The bill also does a second thing in Section 2, where it allows for electronic filing. And I did check with the judge to make sure that they had a system. I know with the Superior Court, we had a company actually put that together for us. He says that they already have that. So it's in place and they're ready to take electronic filings for the hearings that they do. So I'll take any questions if y'all have any for me.
Judge Gunter.
Okay, she's on there. Okay. Mary Margaret Oliver, you there?
Yes, sir. Thank you. Judge Malachi is the Chief Judge of the Office of State Hearings and Appeals. He's done an excellent job. They have more than 30,000 hearings a year, a lot of benefits hearings for food stamps and various programs. So this opportunity for a virtual hearing would be very, very helpful to them. It's a good bill.
Thank you. Thank you for that comment. I knew that they were doing a lot of these and that and that's what they were telling me, was that this would save them a lot of time, a lot of effort. Anything else? Yes, sir, Mr. Chairman.
Mr. Chairman, thank you. I would just agree with Representative Oliver and just say that potentially you're also making this much easier for parties who are able to file through the electronic filing means and the appearance of witnesses, joining remotely. So it seems to me that there's the potential for great efficiencies here also within the court for parties and witnesses as well.
Okay.
Thank you.
Thank you. Anything else? Oh, yeah. Dominic Caprero? Are you? There you are. And I'm probably butchered your name, but if you'd like to speak, come on up. I know you and I have been communicating.
Yes, sir. Thanks so much. Judge Malley, he sends his regards. He regrets he couldn't be here. He's actually in a hearing today.
Okay.
But we're just here. My colleague and I, Lisa Boggs, who's OSA's general counsel, are here just in case there are any questions on the bill.
Okay. Thank you very much.
So thank you very much.
All right. Anything else? All right. I guess feels a little awkward doing this on my own motion, but.
Move to pass, Mr. Chairman.
All right. Is there a second? All right. Any further discussion? All those in favor say aye. Aye. Any opposed? All right. Thank you very much. All right. Now we'll move on to House Bill 554, and I'll call on Mr. Ed Lindsay. He's the one that brought this idea to me. This affects our Liz Pendon's notice. It actually, I think, provides a structure for how to deal with it for judges and the courts. So,
thank you, Your Honor. If I can also have up here with me Ryan Millsap, who is the CEO of Black Horse Studios here in Georgia.
yes, sir.
Who can sort of put a little real life flesh to the bones.
All right.
in
And
terms
for the
of
record, just so that everybody
Yeah.
that's out there, we're on LC 412943.
Appreciate it, Mr. Chairman. We're here today to simply tighten up the structure to make sure that there's proper notice that's given to a property owner who, for whom someone wishes to place a lis pendens on, giving that defendant in a lawsuit an opportunity, should they choose to object, give them 10 days notice to file an objection, and then have the judge timely hear that objection and determine if the lis pendens is indeed merited. And wouldn't expect it to be in most cases, but in certain rare cases, perhaps even giving the judge the power to impose a required bond should he feel like it's necessary in a particular case. And also provide a vehicle for at some subsequent time in the same lawsuit, should the parties determine that the property is not impacted by the lawsuit, to give them an opportunity to simply go back into court and simply ask that the lis pendens be removed. And that's essentially what the bill does, is it creates a process giving a property owner proper notice, giving them a chance to object to the lis pendens, requiring the court to take a look at it should there be an objection, and also give an opportunity to take it off. And basically giving the court the ability to administer and control his courtroom and control the lawsuits that are in front of him involving property. And with that, if I may, Mr. Chairman, with your permission, have Mr. Millsap tell, let me give you the precursor here. He's been involved in a case in which the lis pendens was abused. He's not going to discuss the details of that lawsuit, and we're not looking to have an impact on that lawsuit. That lawsuit is something in the past, but he just, as a property owner, as a major property owner in our state, he just wants to make sure that this sort of thing doesn't happen to anyone else.
All right, Mr. Millsap.
Thank you guys for letting me speak to you today. I appreciate it. The reason we're bringing this bill is because I experienced a situation where someone was bringing a lawsuit that actually was not tied to the property legally, but they utilized a lis pendens to extract leverage. And then we had a really hard time getting in front of the court system to deal with that lis pendens because, you don't have to get permission to put a lis pendens on. And so then we needed to go get permission or really get the judge to tell them it had to come off. And we had months and months of delay. And a lis pendens, somebody who's abusing a lis pendens will argue that a lis pendens is just a little notice, letting the world know that there's a dispute. But the problem is practically inside of the world of real estate, a lis pendens functions like a lien. And so I can't sell my property. I can't refinance my property. I can't recapitalize my property with new equity investors. I'm basically completely handcuffed, and my property is held hostage during the time that there's a lis pendens. So what we're trying to do is just take away this really opportunity for abuse that unscrupulous people can use to really leverage things that may or may not have to do with that piece of real estate. But in this case, at least we get it in front of a judge as fast as possible, and we get a resolution as fast as possible, and we don't allow it to be something that can just hang out there and cause problems for the real estate owner just because someone can slap this on the title and basically cloud the title.
Okay. All right. Any questions by the committee for either Mr. Millsap or Mr. Lindsay? All right, I had the 16 flashing.
Thank you, Mr. Millsap, for sharing today, for taking the time to come and for your work to make sure this doesn't impact others in the future. I really, just as I'm thinking through kind of the mechanics of this, it's almost like it's almost like an action to quiet title. You'd almost have a cause of action, really, when somebody does something like that they shouldn't. It'd be like a lien without a basis for it at the time. And I'm curious for another time. It doesn't impact our decision here today, but how that may play into if there is litigation over that, and that we've seen this bill will address that issue. People filing, putting these lis pendens on when they shouldn't. But just mechanically, and this is more from Mr. Lindsay, as I look through just lines 16 to 24, how this would occur. So if you're filing suit and there's a piece of property that's potentially subject to or going to be at issue for disposition determination in the proceeding,
Yes,
just when you file suit, the defendant has 30 days to answer, but along with it, you'd serve them with the motion. And then they'd have 10 days to object after service, I suppose. And if they didn't object, then the court could go on and
Correct.
enter the order at that time. And then it would have the same functional effect of what's taking place now. Whereas now you're filing and you're filing the suit and you're filing the lis pendens simultaneously.
Yeah,
And
we wanted to be fair to both sides. We wanted to be able to expedite the issue should someone feel like they have a legitimate issue that requires it. So we, rather than wait 30 days or 45 days or whatever else, we wanted to be fair to both sides and give the plaintiff an opportunity to make sure that this gets handled very expeditiously as well. Should there be an issue that they feel like for which the lis pendens needs to be filed. So we were trying to be fair to both sides. The key here is to provide notice and give the court an opportunity to be heard.
all right, thank you.
Representative Leonard.
Thank you, Mr. Chairman. Mr. Lindsay, I had just a more comment, I guess, that I would appreciate your responding to it. My understanding, of course, is the lis pendens becomes very important in a divorce case.
Mhm.
And those are generally filed as a matter of course with the complaint. And you raise a good point. They do effectively constitute a lien.
Yes,
That's the intent, I think, of it.
that is.
And what we're doing here seems to me to be a pretty significant change because the burden would traditionally be on the defendant to raise the issue if he felt or she felt the lis pendens were improperly filed. And
The
now
burden
we're
is still on
shifting
the
it.
defendant. The defendant has to file the objection.
Well, correct, but there is no lease pendants from filing the lawsuit, which traditionally you could do simultaneously. Correct.
Correct. Now you have to give the defendant property owner proper notice.
Proper notice.
Yeah.
But you've traditionally not had to do that. You
Correct.
could file it right away.
Correct.
And the burden would be on the defendant to file a motion to have it expunged or canceled or
Yeah,
whatever.
that's correct.
And I just, I wonder, have any domestic relations lawyers commented? Because there doesn't seem to be an exception for a divorce case in here.
There is not. I can only speak to one divorce lawyer, who's my wife, who felt that this was an expeditious way to handle it. And also we have Mary Margaret is also a divorce lawyer, and she's, I believe, a co-sponsor to the bill. And Mary Margaret may be able to speak to that as well. But the key was, either way, we wanted an expeditious process for that issue to be resolved, whether or not the list pendants was proper.
I understand.
Perhaps Mary Margaret, Representative Oliver, can speak to that.
Well, one other question I had, the 10-day limit, if I file my motion with the complaint, is it your intent that 10-day period would run, right after service, or would it be?
Yes.
Okay, thank you.
All right, Mr. Chairman.
Ms. Lindsay, Representative Leverett brought up a point that crossed my mind as well. And I think the question is, if you have a circumstance where it's a divorce case, clearly there's property that's at issue in that case. And, maybe there's an issue as far as getting the other side served, and you're concerned that there may be a disposition of the property or something prior to, the case moving forward, that there could potentially be an issue possibly. And I'm interested if the committee has any thoughts or concerns about that as well. But how would you feel about an exception for family law cases to this legislation? So this would apply outside of the divorce context.
We would have to take a look at the amendment and make sure that there's certain due process protections are still in place, even in those situations. But yeah, I mean, if there's some type of domestic law exception that you feel is necessary, we'd be happy to take a look at the amendment.
Conceptually, would you have any objection to that?
I don't think so, as long as due process is being protected. And perhaps Representative Oliver, who does a large amount of divorce work, would perhaps have some thoughts on the subject.
Well, while my mic's still on, I don't have any problem moving the bill forward and us having that conversation before a full committee, if that's where things are headed. I know crossover day soon. Thank you.
Yeah.
All right.
She wanted to speak.
Representative Oliver.
Ms. Chair, I think moving this bill to full committee and taking a pause to at least ask the family law section folks what they think would be a good idea. Most of the counties I'm dealing with have injunctive standing orders that prevent transfers of properties. I just don't know if all 40 plus judicial circuits have standing orders that prevent transfers. And you're right, until either a standing order or a complaint is filed, served rather, it's hard to know the effectiveness of it. So I think it's a good idea to let the family law section look at this overnight. I'm thinking that the standing orders are protective of domestic relation litigants, but again, I don't know. Do you have a standing order in Elbert County, for instance, that prevent transfer of any properties? Assets?
We do, Representative Oliver, but the concern I still have is I still don't think that constitutes a lease pendants as to the property, because it doesn't put a third party on notice necessarily. And let me say this: if this is just my concern, I'm happy for us to do as the chairman suggested and get the bill out onto the full committee. It's just it seems to me to be a significant change in a sort of obscure piece of Georgia law that may turn out to have been more important than we realized. That was my only concern.
So I do think, in our discussions, with other real estate lawyers, it has come up.
And here.
Yeah, this is the problem.
You need to get at the microphone. So they,
yeah, that in my discussion, since we have filed, it's not simply a situation that Mr. Millsap has dealt with, but this is a real problem in litigation, making sure that the court has control over the list pendants, and that there's a proper ability to have notice and have the court also have control in order to be able to take it off should it be proper. But more than happy to sort of consider any kind of carve out for domestic relations should that be a problem, and work with you and the chairman and Representative Oliver on that issue, if that's a concern. Throughout the entire process, I might point out.
And I'll just say one thing. You know, our concern is really around commercial real estate.
That's what I'm saying.
And the abuse of a list pendants in order to extract payments, you know, in a kind of extortive sense. And so the way that can be combated is by having a quick hearing. And the difficulty right now is that somebody can put a list pendants on, and then the property owner has to go beg and plead the court to hear this. And for us, it took months and months because the court said, well, that's not an emergency. It's just a notice. But it's a huge emergency when you're the real estate owner and you have loans due and you need to be able to move on with your life to capitalize the property correctly. And until that list pendants is removed, nobody will touch it.
And I appreciate that.
All right. Anything further?
You ready for a motion?
Anything else? Any further discussion with? All right. Mr. Lindsay, Mr. Millsap, thank you very much. All right. Any further discussion as to the bill? All right. Do I hear a motion?
Move to pass.
Do I hear a second? All right. I have a motion and a second. All those in favor say aye. Any opposed? All right. It passes to the full committee. And I believe that's our last one. All right. We're adjourned. Thank you.